recording right now.
Okay. So after this presentation, it will get uploaded and you'll get a link that'll give you a link to the slides if you'd like to have a set, as well as if you wanted to re-watch any part of this. So good morning, everybody. My name is Elena Liederbach. I'm a certified elder law attorney. Elder law encompasses special needs planning and working with families who have a child with special needs or another family member. I've been with the firm for, about 25 years. This is my second career. Prior to going to law school, I worked in the mental health system. I was a rehabilitation counselor and then ran some programs for persons with mental illness. And so when I decided to go to law school, I really wanted to stay in the area of helping people with disabilities. So this is the only firm I've ever worked at. And as George said, I think what we do is very gratifying and very positive, hopefully, in that we're trying to help people navigate through all the things that they're dealing with. So you can go ahead, George. So I'm going to add to what George said in terms of the overview, is that the focus of our presentation this morning is going to be looking at ways of protecting assets that really belong to the individual with the disability or with the special needs. We're not looking at third-party money. It's really more about when, assuming it's your child, that maybe they've inherited something, or maybe they're working and accumulating funds, and what do we got to do to make sure that they don't lose, if they are on means-tested benefits, that they don't lose those benefits. So, there's other kinds of aspects of special needs planning, but we're only focusing on the situations where it's that disabled individual's funds. Go ahead. All right, and before we jump in, we're going to go over a few terms and acronyms that you will hear in the special needs planning arena. So the big one is a trust. A lot of times trust seems like it's a mysterious thing. And what it is it's a legal arrangement, or I think of it as a contract where it's created by one person who's called the settlor. Sometimes they're called the grantor, but it's an individual that's going to create it, meaning that they're going to have a document that's going to spell out all the rules. And the settlor will appoint someone who is called the trustee, who's going to be in charge of managing whatever assets that trust is going to contain. And they have to manage it on behalf of a beneficiary, the person for whose benefit this trust is being set up. So think of the trust agreement itself as a contract that sets out all the rules for the trustee so they know what they can and can't do. Once that's created, that becomes like a legal entity, almost like a separate legal entity. All right, SSI, I'm more on trust in a little bit. SSI, it stands for Supplemental Security Income. It is a benefit that is provided through the Social Security Administration. It's means tested cash assistance. What that means is that in order for an individual to be eligible for SSI, they can't have very much money. They have to have very limited assets. And that number is currently it's $2,000 in order to qualify for SSI. Medicaid is also means tested. Same rule, you have to have less than $2,000 in order to receive medical or health insurance coverage for the individual. All right, special needs trust is a type of trust. So there are many, many different types of trusts out there, but the ones we're focusing on are special needs trusts. In other words, They are for somebody who has disabilities. And the special needs trust allows for assets to be put in or added to that trust, and the individual and the assets in that trust are not going to count against that $2,000 limit. So that way the individual can keep their SSI and Medicaid. Special needs trusts are defined by Social Security and Medicaid. They have specific rules that have to be met in order for them to be recognized as a special needs trust, and exempting those assets against the $2,000 limit. A pool trust is another type of a special needs trust. The difference is that it is managed by a nonprofit organization for the person with disabilities. It's as opposed to being sort of a private standalone trust. And we're going to get into that in a little bit as well. And stable accounts, which is the other part of our talk today, is not a trust, but it's a type of saving or investment account that's been authorized under the ABLE Act. It's a federal law. It stands for Achieving Better Life Experiences. That says that if an individual places funds into a stable account, those two will be exempt, just like funds that are in a special needs trust. Okay. All right, I think we're missing some words there, but it's supposed to say special needs trust, but it's just a placeholder. So go ahead. Oh, there it is. There's delay. All right, go ahead, George.
There we go.
So before we jump in further, I want to just kind of go back to revisiting in the special needs planning world, there are three types of special needs trusts. We're only going to talk about two out of these three. So the first one is a first party special needs trust, which means that it's funded with assets that belong to that beneficiary, the disabled individual. The second is a third party special needs trust, which is funded not with the individual's funds, but with third party money. So third party can be mom or dad, grandparents, any other individual that wants to provide for that disabled beneficiary. And the way they can do that without jeopardizing their eligibility for Medicaid or SSI is to put the funds into a third-party special needs trust. Both first party and third party, once they're established, they're administered pretty much the same way, same rules, but it's important to distinguish that one can only hold first party money, and the other, it has to be funded with third party. And we'll talk about why in a little bit. A pool trust is also funded with the assets of the disabled individual. There are some pool trust organizations out there that will also offer a separate pool trust that can be funded with third-party funds. Pool trust organizations, by the way, exist throughout the country. Here in Ohio, we have a couple that we use, and we'll talk about that as well in a little bit. But go ahead. All right, so back to first party special needs trust. So the elements of a first party special needs trust, meaning this is how they have to be created and administered, is number one, that they established, in other words, that settlor, that person who's creating the trust, under the rules, it has to be established by either a parent, grandparent, guardian, court, or the disabled individual themselves. That's number one. You'd ask, well, why would a court establish the trust? Well, the reason the court would is if there is a guardianship, say the person is over age 18 and they've come into some money, then the court would have to issue an order authorizing that guardian to establish the trust. Sometimes the person is if it's a minor child and maybe there's a lawsuit, maybe there was a birth injury or some kind of a personal injury to that child, then the court would also in that situation establish a trust if that's what we were going to, if that was the goal, is to place the funds into a trust. It has to be funded with the assets of the disabled individual. Again, that's what makes it a first party trust, so that the funds belong to that individual legally, and that the trustee has to then use the assets of that trust for the benefit of the individual. So there are some restrictions of how that trust, what the trustee can use those funds, or how they can make those distributions, how they can pay for things that individual needs. One of them is that they can't give cash to that individual, because if they do, that's going to count as income, unearned income to that individual, and may impact their eligibility for SSI or Medicaid. And there's some other restrictions which we will get into a little bit. The trust has to include a clause that says that upon death of that beneficiary, that the state will be repaid first before anything else for the amount of Medicaid they paid while that individual was alive. So that's really why we want to separate first party money from third party money, because if we have a third party funded trust, then we don't need to have that Medicaid payback provision. But if we have a first party trust, we do, because the state's recognizing, hey, we know you got money, we're going to let you put it in a first party trust, and we're going to also give you Medicaid. And we're okay with that as long as you follow the rules of that trust. But upon death, if there's money remaining in that trust, we want to be reimbursed. So that's why that provision is there. So first party trusts are a planning tool in our special needs planning toolbox, so to speak, that's been around for a long time. And we know that it's a way to provide for the individual and protect their benefits or eligibility for SSI and Medicaid. Okay. All right, so here's a couple of the rules. I know we touched on it, but here's the requirements for the beneficiary, like who can be the beneficiary and how do we select a trustee. So the beneficiary, in order for it to be meet the special needs trust requirements, it has to be an individual that meets the definition of being disabled. So when we talk about words like disabled or disability, we have to distinguish that every program or agency has their own definition for disability or considering someone disabled. So with special needs trust, we're looking at Social Security's definition of disability. So the person has to meet that definition. The trust itself has to be established prior to age 65, the beneficiary's age. They must be under 65. This is for the first party special needs trust. Assets or funds can be added to the trust as long as the individual is under age 65. Once they hit 65, there can't be any more added to that first party special needs trust, but the trust is available to continue paying for services or items that individual needs, even though they are over age 65. All right. So the trustee who administers this trust, who's in charge of it, they are selected by that settlor, the person that created the trust. Remember, the parent, grandparent, guardian, court, or the individual. It cannot be the individual, the disabled individual. They can't be both the beneficiary and the trustee. They can only be the beneficiary. The trustee then has the responsibility for managing whatever is transferred to the trust. If there's investments, if there's a house that the trust purchases, whatever that property is, they have to manage it. The trustee's also responsible for filing any taxes that result because of the trust. They may have reporting requirements to Social Security or to probate court. So if the individual is on SSI, they have to, the existence of the trust has to be disclosed when the trust is funded and available for the individual. And what the rule says is that you're supposed to disclose it within 10 days following the month that the trust was established. So when we're sometimes involved in a case where there's some settlement coming into that disabled individual, and we got to set up a trust so that they don't lose their SSI, we will, once that trust is established and funded, we will send a notice to SSI to letting them know, hey, here's the trust, and oh, by the way, we point out, here's the rule that requires Social Security that you ignore the assets in the trust, that they're exempt and not countable against this individual. If the trust was established by probate court, by the judge, and the court sometimes will retain, we call it retain jurisdiction. In other words, they're going to retain supervision over that trust. They're going to so that we would need to provide regular accounting to the court about what's in the trust. And we would also need to ask the court for permission before we can spend any of the money of the trust. And this is because the court is supervising and making sure that the trust is being properly used for that individual with a disability. The trustee can employ, they're not expected to know everything. They may not know how to interact with the court, how to report. So the trust allows them to hire advisors, could be an investment advisor, if it's a sizable trust. They can hire attorneys or other professionals to assist and guide them, and they can use the funds from the trust to pay for those services. Okay.
We had a question that I think would be a good answer now. So Melissa writes that if the individual with disabilities will inherit assets from a parent or relative, is that asset considered a first party or third party?
So the answer is if the relative or whoever just names that disabled individual as the recipient of the inheritance, then that would have to be placed in a first party trust. Because remember, we said the funds have to be owned by that individual. And when it's an inheritance, then that becomes, that person becomes legally entitled to those funds. So if we want to make it a third party trust, or if we don't want it to go into a first party trust, then the way to do that is the parent, grandparent, relative, whoever wants to provide for that individual. The way to do that is to have a third party trust created, and then through their own estate planning, like a will or their own trust, have those funds be directed to a third party trust rather than the individual themselves. And by doing that, we can avoid the Medicaid payback on death requirement. Was there another question, George?
No, that was
okay.
That was the only one so far. So
okay. All right. So what kind of property can the trust own? You know, we use these words interchangeably, or at least I do: property, assets, funds. But for a first party trust, the trust itself can hold any type of property that the individual could own. So that means a bank account, a house, a car, an investment, any of those types of things the trust can own. Anything you or I can own. The way that's owned is that instead of it being in the name of Elena Lederbach, the individual on the account, it would be John Smith, trustee of the Andrew Smith Trust. So that's how it would be titled, and that's what makes it a trust asset. Trust, the first party trust can also have some of the beneficiary's income assigned to it, but there's a asterisk to this. So there's not all kinds of income is assignable to a trust based on Social Security rules. So for example, if the individual is receiving SSI or SSDI, they can't assign the income to a trust. But maybe if they have some, maybe if they have they're working, they can assign their income to the trust. And why would we want to assign income? Well, because when we receive SSI, they're looking at both the income and assets. And if our income is high, then that might reduce the amount of SSI we get. So many times we're looking at, is this a type of income that we can assign to a trust? The trust has a separate tax ID number. So what that means is that when we create the trust, we would get an EIN or a tax ID number through the IRS assigned rather than using the individual's Social Security number. So that it's recognized as a separate thing from the individual. But having said that, we also structure it so that any trust income that's earned is going to be included in the beneficiary's tax return and not charged against the trust. Meaning that if you have a separate tax ID number, you're a separate taxing entity. And normally, if the trust earns more than $600 in income in a tax year, then the trustee has to file an income tax return on the trust. But, and this is getting really into the weeds, but we would rather pass that income and make it accountable to the beneficiary rather than the trust, because as individuals, our tax rate is much lower than when we have a trust tax, that it's a much higher rate. So, all right, and then we already said that the trust assets can only be used for the benefit of the beneficiary, which sometimes is challenging because maybe the beneficiary wants to purchase presents for Christmas presents or some kind of gifts to other people, and we have to say no, you can't do that. It can only be used for that beneficiary. The limitations of the trust property is that distributions from the trust. Oh, so if the trustee gave money to that individual right out of the trust, then that would be treated as unearned income by SSI and Medicaid. And what that means is that when somebody's on SSI and they're receiving the full benefit amount, if they receive unearned income, then what Social Security does is they disregard the first $20 in the month of unearned income, but after that, they reduce the SSI benefit dollar for dollar. So $1 of unearned income is going to reduce the SSI benefit by $1. So that's why we want to avoid giving that individual any money. But what the trustee can do is directly pay for the item or service that the individual, for the individual. And so say we're going to buy a mattress, the person needs a $600 mattress. Rather than giving them $600, the trustee just purchases the mattress. And under the SSI and Medicaid rules, that's perfectly okay. And it will not reduce their SSI. There are some purchases that if the trustee makes are going to affect the SSI. And those are what we call food and shelter expenses. So the trust, if the trust purchases groceries or pays rent for that individual or utilities, then Social Security is going to consider it, they call it in-kind support and maintenance. Sometimes you hear us calling it ISM, which stands for in-kind support and maintenance. And what that means is that under the Social Security rules, they're going to reduce their SSI benefit because of the in-kind support maintenance. And the reason for that is in Social Security world, the SSI benefit that they're giving someone is supposed to be used to pay for food and shelter types of expenses. And so if there's a third party, including a trust, that's paying for those expenses, that will reduce the SSI. Now, they can't reduce it dollar for dollar, unlike cash. They're limited under their own rules that they can reduce the benefit by 1/3. That's the maximum. Okay, go ahead. All right, and then, so we've talked about the first party special needs trust. And so now I want to touch upon a little bit about the pool trust. So as we said earlier, pool trust is managed by a nonprofit organization. And they exist and they have a trust in existence already, where the nonprofit is the one that's managing the trust, and then there's some other entity that's holding the funds in that trust. So that's going to be a bank, and they're going to invest the funds. And the nonprofit, the pool trust, allows individuals who are disabled to join that trust, and they complete what's called a joinder agreement, and then they move their money to that pool trust. And so the pool trust then pools everybody's money. So all the individuals with disabilities, they'll pool their money together for purposes of investment and management. That keeps the cost down, but they trace everybody's share separately. So that the individual will receive a statement periodically that will say, this is your share of this trust. So I'll just look at, okay. And so they will also manage it similarly to a standalone first party trust. In other words, they will not make distributions for food or shelter types of things. And that's because they are making sure that they don't disrupt the individual's benefits. One of the restrictions is, at least the pool trust organization that we work with that's local here, they will only accept cash. They will not accept real estate, securities, or other properties. It won't hold a car or title to a car or a house, that kind of thing. As I said, there's pool trusts are all over the country, and the rules specific to pool trust vary state to state. In Ohio, we can have an individual with a disability of any age establish a pool trust. So they're not limited to that age 65 that we have for that standalone first party special needs trust. But that's not true for every state. So if your person moves or you move and you want to do a pool trust, you need to to another state, you need to check and see whether the 65, if there's a say age 65 limit or not. Okay. Oh, let me just say before you jump, I'm sorry, I just saw my last line on there. Okay, so I just said that thing about the age 65. So you can be of any age and set up, if you're disabled, and establish a pool trust account for yourself. However, if you're on SSI, they have this specific rule that if you're over age 65 and on SSI and you establish a pool trust, then they'll let you do that. It'll be exempt, but they impose what's called a transfer penalty. They're penalizing the person because they're over age 65 and they move their money to a pool trust. The penalty can be up to 3 years maximum, meaning that you would lose the SSI for that long. It depends on how long the penalty lasts, is based on the amount that was transferred to the trust. It's kind of a weird rule, but it is limited to people over 65. I just saw a question here.
All right. So we do have one question. So do the Social Security reporting requirements apply to third-party trusts as well as first-party trusts?
So there's some differences of opinion about that. Our position's been that until that third-party trust is funded and being used for that beneficiary, we do not report it because there's nothing happening. So sometimes parents will set up a third-party trust, but not fund it until their death. That's when the money goes over there. So we're not going to report an unfunded trust. But once it's funded and available to that individual, Social Security and Medicaid are entitled to that information. Okay, then what is the reason you would choose a pool trust rather than a first party trust? Oh, well, okay. Do we have well, let me just briefly answer it now. So the reason would be that typically it's because there's no one we can identify that can serve as trustee of a standalone trust. And so that happens from time to time. We have parents who, while they're alive and doing okay, they can manage things, but there's no one after they're no longer around that can do that, and or no one that they will trust to do it and follow what the trust says. So in those situations, the pool trust is a good alternative because they know what they're doing in terms of the Medicaid rules and SSI rules, and they're going to protect that person's benefits. Okay.
And then we had one other question. Just SNT trust money should be used for personal uses and interests and not rent and food, etc.
I'm sorry, what is the question? I see.
Yeah.
Okay. So yes, so let me speak to that a little bit more. So in general, we would discourage the trust from paying for food and shelter expenses. So that's rent, food, utilities. But sometimes, because that's going to cause a reduction of the SSI benefit. But sometimes, the SSI benefit is $900 and something a month. And realistically, how a person can survive on $900 a month for their food and shelter needs, it's difficult, right? So sometimes if the trust is used to pay rent for better housing, better food and shelter for the individual, you kind of do the analysis, say, yes, they'll take a hit on the SSI being reduced, but they're in a better living situation. So the trustee may decide it's worth it to do it. So we're not saying that the trust can't pay for food or shelter, but you want to do the analysis to say, will this really add to the person's quality of life, or is it better to focus on maximizing their SSI benefits?
Okay. So some of the questions that we have, if you got a question that's sort of more specific for your particular situation, send us an email or give us a call. We're happy to either do a consultation or even chat with you for a few minutes over the phone about your specific issues. But we'll try to keep things moving here so we can get through all of our material. So
and if we I'm sorry, I'm just going to add in, if we have time when we finish, we're happy to go revisit these remaining questions.
Absolutely. Okay. All right. So was Elena's very good overview and details about special needs trusts. Yeah, special needs trusts have been well established. They've been around for several decades now. The relative newcomer on the scene are these stable accounts. These were permitted under the Affordable Care Act legislation, the large healthcare reform that was passed in 2014. And Ohio was one of the first states to take advantage of that new legislation and set up their own system that they call a stable account system. So the way to think about a stable account is, you might be familiar with 529 college savings accounts or perhaps your 401k or other retirement investment account. And it's a similar concept. In fact, the ABLE account laws are actually in the IRS code, not in the Social Security rules as such. So the funds that you can place into a 529, or I'm sorry, into a stable account, they're invested and they grow tax-free. The distributions, if they're used for specifically qualified purposes, are not taxed as income to the individual, similar to how, in your 529 account, if those funds are used for college, approved college expenses, they are not taxed as income. The stable account is permitted to have a maximum of $17,000 added to it per year, and this amount is adjusted annually. Now, this is $17,000 from all sources, not just the individuals, disabled individuals' contributions, but anybody else can also contribute, but the total amount added to it cannot exceed $17,000 a year. For SSI recipients, the maximum amount that account can have in it before it starts counting as a resource is $100,000. For all other purposes, the maximum amount that can be in there is $517,000. And that maximum, that 517 number, is adjusted annually. As far as I can tell, that SSI number is fixed until they pass further legislation to adjust it, perhaps. So once the account exceeds $100,000, SSI will start counting each additional dollar as they would as a resource towards that $2,000 limit. When it reaches $517,000, it simply further contributions are rejected. The account cannot exceed 517. So if somebody tries to add funds that will exceed that, their funds are returned through the system. So the eligibility for a stable account is that the individual, the beneficiary of that account, has to have been determined blind or disabled before reaching age 26. Why 26? It's really, there's no logical reason for it. My suspicion is that it had to do with the sausage making process that was the legislation. If you recall, under the ACA Affordable Care Act, individuals could stay on their parents' plan until age 26, et cetera. I think that probably had more to do with its budget score than anything else. Unfortunately, it is one of the biggest restrictions on stable accounts. So many individuals don't get their disability determination until they are older than age 26. And unfortunately, as of now, for those individuals, stable accounts simply aren't available to them. But the individual, if they are blind or disabled prior to age 26, either they were determined disabled by Social Security, so they had a formal determination, or they have a condition, a diagnosis listed on the Social Security's list of compassionate allowance conditions. So there is that list of conditions where, even though you aren't necessarily getting disability based on it, you have that diagnosis, and therefore you are permitted to use a stable account. Or that person self-certifies that they would meet the Social Security disability test if they apply. And this is an interesting wrinkle to this, because as Elena alluded to earlier, Social Security has its own rules for determining whether somebody is disabled, and they have a different criteria for an adult versus a child, somebody under age 18. For an adult, it boils down to, can you earn a living? Can you engage in substantial gainful activity? Or does your disability limit you in doing that? The stable account, which again is IRS, the IRS is the one who makes these determinations. They actually use the criteria for a child, a disabled child, for people of all beneficiaries. So, and that is, they have to have a diagnosis of a physical or mental impairment that results in marked and severe functional limitation. That impairment has to last or be expected to last for greater than a year. When you create a stable account, they're not going to ask up front for that written diagnosis. Again, this is the self-certification. You attest that you meet this criteria. However, the written diagnosis can be asked for. Medicaid could ask for it. Social Security could ask for it at any point in order to verify that you do indeed meet these requirements. So, the self-certification test is easier to meet than the test for adult disability. So that is one benefit of the stable accounts for somebody who was determined disabled or had their condition manifest before they reached age 26. This test is easier to meet than the test for adult disability. So somebody could not be able to meet the threshold to receive SSI benefits, but they still may be able to take advantage of a stable account in order to get Medicaid. So that's one of the benefits here. And the important thing to remember is that it's the age 26 is not how old the person is when they create the stable account. It's how old they were when their disability manifested. So somebody, so for example, these only came into effect in 2014. Somebody who was 35 at the time, who had been disabled since birth, would still be able to use a stable account because their disability was manifested before age 26. I think that's a key thing to keep in mind here. So the stable accounts, they really designed it to be self-help. A special needs trust, you need to come to an attorney like us in order to create this. They're a legal instrument that needs to comport with a lot of legal requirements, not just Social Security, but trust law and estate law in general. Stable accounts, they deliberately designed it so that individuals could create these with the minimum amount with minimal barriers. So the account can be opened by any of the individuals that we've got listed here in the order that they appear. So for example, a parent cannot establish a stable account if the disabled individual themselves is able and willing to open the account for themselves. So the disabled individual can open up their own account, their POA, their guardian, their spouse, their parent, a sibling, a grandparent, or if all else fails, if there is no one else, the Social Security representative payee, their SSA can open their account for them. Which this is a broader category than what we saw with special needs trusts. Special needs trust, it is the individual, their parent, their grandparent, or their court or guardian. So there's more individuals who can be in this person's life and help them establish a stable account. So this is an important thing to remember with a stable account, that any person can contribute to that account. So the individual themselves, if they get earn money or receive funds, can put it into the stable account. But a trust or an estate that they are the beneficiary of can also contribute. And this is where the special needs trust and the stable account really can work hand in glove, because as you'll see, what the stable account can pay for is broader than what a special needs trust can pay for. So you can make them work together very well, as we'll see. So as I said, $17,000 per year from all sources. If the individual is working, they can contribute an additional amount of their own earned funds to that trust as well. So the individual can earn additional income, they earn additional assets and put them in their stable account. If the beneficiary has a sibling who is also disabled, heaven forbid that beneficiary pass away, that account can be switched. The beneficiary of that account can be switched to their disabled sibling. And the account can also be rolled over from another family member's stable account. So if you have two siblings, they each have a stable account. You're only permitted to have one stable account per individual. If the individual sibling passes away, that sibling's stable account can be rolled over into the stable account of the surviving child. So, however, not a 529 account. So if you have one sibling with a college savings account and one with a stable, and heaven forbid the individual with the 529, the college savings account, passes away, it cannot roll over into the stable account. And again, maximum account $517,000. So regardless, the individual's stable account cannot exceed that amount. So how do the various public benefit programs view stable accounts? So SSI eligibility is suspended if the account exceeds $100,000. I don't know if that's actually if it's at 101,000. It's simply that after 100,000, each dollar counts towards their $2,000 limit. However, other benefits are unaffected over 100,000. Like a special needs trust, a stable account must have a Medicaid payback provision upon death of the beneficiary, unless it's able to be rolled over to another qualified beneficiary. The allowable uses of funds, they're called qualified disability expenses, and this is a much broader category than the special needs trust. Anything that's related to the beneficiary's disability, that's for that beneficiary's benefit. Things that are used to maintain or improve their health, independence, or quality of life. And there's actually a list, and as you can see, it includes things like education, housing, transportation, job training, technology, health and wellness, management, administrative things, legal fees, the expenses for the account oversight, funeral and burial, and basic living expenses. And I would highlight the two here, the housing and the basic living expenses. This is your food and shelter expenses. So a lot of times when you have an individual who would be able to have both a special needs trust and a stable account, that special needs trust could distribute to the stable account, and the stable account could then pay rent or for food, and that would not trigger SSI's limitation on food and shelter expenses. So they work well together. They dovetail, and it's really, we wish that more individuals could use stable accounts because they really enhance what those special needs trusts can do. So, there's a lot less to say about stable accounts than special needs trusts. In a lot of ways, they are a much more straightforward type of arrangement. There's something that most people are likely more familiar with. They're similar to a retirement account, a savings account. So when do you use one? When do you use the other? So generally, if you're going to use them together, as I said, using them together, if you have a special needs trust and a stable account, your special needs trust is going to hold the bulk of the asset and anything that is a non-cash property, such as the home or the car. The trustee is the one who is in charge of those assets, and the trustee then would make distributions to the stable account. The beneficiary will have direct access to that stable account. Now, what we will typically have the beneficiary get arranged for the beneficiary is something called a TrueLink card. This is a reloadable debit card that can be linked to that stable account, where amounts of money can be loaded onto that card, and that card can be used just as you would any debit card to make everyday purchases. You can, with the TrueLink card, guardrails can be set up on it so that individual doesn't inadvertently use the funds for something that's not permissible or something that is not something that's in their best interest. So you can limit its purchases of alcohol. You can limit its use at gambling and casino sites. You can limit it use for online purchases. There's a whole list of categories and ways that you can tailor that TrueLink card's use so that the beneficiary has independence and has the ability to use their card as they desire, but isn't going to inadvertently cause a problem for themselves. So, and again, the stable account can be used to pay for food and shelter. So you will avoid being penalized, that 1/3 reduction by SSI, if you first distribute funds from the special needs trust into the stable account before using those funds for food and shelter. And I'm just checking the questions here. So does it make sense to have a special needs trust and stable with SSI money? So if somebody's on SSI and they're receiving their monthly payments, if they have a guardian, typically that guardian will also be their representative payee for Social Security purposes. So they will have that representative payee will have an account that the SSI money gets deposited into. And what we would typically advise is that if the individual's account is going to go over $2,000 because money is accumulating in there, that they would then put the excess either into a special needs trust or into the stable account, so that the beneficiary doesn't go over the asset limit. Again, the stable account can only get up to $17,000 added to it every year. So if you are putting significant overages into a stable account, it might be worth it to get a special needs trust put in place to receive that excess, because there is no limitation with an SNT for the contribution. Income, unlike a special needs trust, income cannot be assigned to a stable account. It has to be received by the individual before they transfer that into the stable account.
Hey, George, can I just add something to that, just in case there's any confusion? So in SSI world and Medicaid world, they define income and assets differently. So income is the money that comes in during the month. So if I get SSI this month, that's my income. But to the extent I don't spend that SSI during the month of May, then whatever remains in June now becomes an asset or a resource. So for SSI, the resource limit is $2,000. So I think what George was saying, that if you have unspent SSI, then it's going to become an asset. And then if there's a danger that it's going to climb over 2,000, that's when you want to move that excess. And you can do that either to a stable or an SNT.
Yes. Yeah. Thank you, Ellen. That's probably a question I answer at least 3 times every week, explaining how that works. And And I think a lot of people, they get confused between, we say assets, income, what are the differences? And as Elena, explained, it's the distinction between the two. Okay, I'm just going to briefly pause on this page. The slides will be posted on the website along with the video. So this is more for your reference, just to kind of keep all of these things straight as to what is a stable account, the private special needs trust, and the pooled trust, and their various features. So you can take a look at this for your reference down the road here. So Elena, do you want me to do this slide and then you take over, or how?
Sure, that's fine. I want to add on to the slide too, though. So go ahead and do your thing.
Okay. So what are the advantages and disadvantages? So for a stable, it's easy to set up. You would use it for saving the individual's unspent SSI or their earnings if they work. If they're going to receive a small lump sum, so say grandma left $5,000 for them in her will, stable account can be used to receive, to have that. If they are going to be receiving child support payments, you can have the stable account. They can put those child support monthly payments into that. The private special needs trust, if they're going to be receiving a larger inheritance, they're not going to be receiving $5,000 from grandma. They're going to be receiving $50,000 from grandma. That's where you want to use a special needs trust. Or if there's going to be property other than cash. So somebody they're going to inherit a house, you want to use a special needs trust. Or if they're going to be receiving a recurring income stream. So if their settlement from a lawsuit is going to be a structured settlement, it's going to give them monthly payments, then you can direct those into a private special needs trust, so that they're not only are they as they build up not counted as a resource, those payments themselves aren't considered income either. Then the pooled trust, again, this is an easier, less intensive management arrangement. So if you're going to receive one of those smaller lump sums, but the individual doesn't qualify for a stable account, they can set up a pooled trust. It's easier and cheaper than doing a special needs trust. Again, if the amount's not going to be enough to justify an institutional trustee, but there's no family member or other person who's able to serve as trustee, a pooled trust is a good option. Or if the individual is over age 65 and they're receiving Medicaid, then there's really no other option. The private special needs trust is no longer permissible, and if they receive whatever it is outright, they're going to lose their Medicaid benefits. So a pooled trust is a good option in that scenario.
Can I just clarify the child support payments issue? So as George said, you can add child support payments to a stable account if you're receiving child support for your child, but just know that child support is treated as unearned income. So it will, if that child is on SSI, it will reduce their SSI benefit dollar for dollar every month that child support comes. You can add it to the stable account, and then it won't be a countable resource, but it will be income. If you want to maximize the SSI benefit and not have the child support count as income, then a way to achieve that is instead having the court that maybe granted the divorce or ordered the child support, the court can order that the future child support payments be directed to either a pool trust or a private special needs trust, first party special needs trust. And if it's handled that way, then that will avoid the child support to be counted as unearned income. That's the only way we can do that. It doesn't work with a stable account because I don't know why, that's just the Social Security rules. But they will allow, if it's an order, in other words, they're gonna say, well, then it can't be unearned income to the individual because they don't get to control it. It's been ordered to a special needs trust.
Okay.
Okay.
A couple of questions. By using the term private special needs trust, since the beginning, since that first little bit, every time that we're referring to a special needs trust, we're going to be talking about a first party special needs trust. That term private special needs trust is simply to distinguish it from a pooled trust, because they are both special needs trusts, but one is a private trust that is established by the beneficiary themselves, whereas a pooled trust is an organization. And then the $17,000 limit, it is not a net amount. It is the sum total of contribution. So if you have a stable account with $30,000 in it and you take out $20,000, you can still only add 17 to it, that year. It's each dollar that's contributed to it reduces that $17,000 allowable amount. So it's not a net. It's the gross amount put into it. All right. So. All right. Elena, why don't you go ahead?
Okay. All right. So what are the pros and cons of stable accounts? Well, the pros are that they're very easy to set up and you don't need an attorney to do it. Although I will say this week sometimes parents will ask for our assistants to do it because maybe they're not computer savvy or they're not sure and they would feel better if we did it. So we'll sit down in front of a computer together. And I learned this week, I had a mom come, and we were setting up a stable account for her daughter. And her daughter is young, so say early 20s. And you kind of go on the website and you put in the answers. And then you get to a page where they want to verify your identity. So then they'll say, we're going to give you 5 questions to verify it's you. And because the daughter's so young, it kicked out, oh, we can't, you're going to have to call in this number. And it turned out because they don't have enough information about her as an individual, because she hasn't had credit or paid rent or anything, they required that we download a form, fill it out, and fax it in or mail it in. So there's some additional steps, but it's not rocket science. You just kind of have to be aware that you may not be able to set it up exactly that day. But otherwise, when we've done it with older individuals, you set it up on the computer. Once it's set up, you transfer some money over to get it funded from another account. And then it's pretty simple to administer. Like George said, you can get a debit card attached to it that's preloaded, and then the individual can just use it when they go wherever. And as long as they're spending it on themselves, it's fine. It does ask you to select an investment goal. So they give you, I think, 4 or 5 options of how much risk you want to take on or how conservative you want to be. And the individual has direct access. So those are all, they don't have to go to a trustee and say, hey, can you pay for my bowling? So it gives them, I think it also gives people some sense of control and independence. And for many individuals, that's a good thing. And families want to foster that. The cons are, well, that one says it's available for individuals disabled prior to age 26. That's true. But there's been some recent legislation that's been adopted that is going to increase that age in 2026, so 3 years out. They're going to increase that age to 46. So that should open up the stable account for more folks, because we frequently have someone that became disabled later in life, maybe a car accident or something. And because they didn't meet that under 26, they're excluded. So this is going to open it up more. And don't ask me why we have to wait 2 years for that, or 3 years. The other con is that it's limited, as George said. You can only deposit $17,000 total. So if mom puts money in and dad puts money in and grandma puts money in, all of that can't exceed $17,000 in a calendar year. Another drawback is that it can only hold cash or liquid assets, so you can't put a house in it or a car or anything other than cash. And you cannot assign income to it. Like I was saying earlier, you can't assign the child support payments like they can be to a special needs trust. The other con I'm going to throw out there is, depending on your special needs person, your person with a disability, this may be a good option if they're able to manage the funds. In other words, can they use the card appropriately? But sometimes we have a child that maybe is easily influenced by other people out there who are not well-meaning, and so they could be potentially taken advantage of. And so they may not be, the stable account may not be the right tool. But it is a tool, and so you have to kind of look at your own situation to decide whether the stable account would be a plus or a minus. Okay. Go ahead, George.
Okay.
Did I skip a question?
Yeah. So there's a good question here. Can you have the child support discontinued when they turn 18? Because it's going to decrease the SSI payment. The answer is, rather than have that support discontinued, you could have a special needs trust created and have that child support income assigned to it. You can assign child support to a special needs trust. So if it makes sense, if you want to have your SSI and your child support, special needs trust is the way to go there.
And it could be either a first party special needs trust or a pool trust. Either one of those, right. It can be assigned to. Right.
Somebody who's done a stable account, they pointed out that you can, as within the stable account system, establish a gift page that caps the limit for the various people who want to give gifts, and that's very handy. What I would point out is that if you have a lot of individuals out there who want to give and contribute for the benefit of that disabled individual, you may be better off doing a third-party trust, what I would call the wholly discretionary trust, that third-party special needs trust, because that can be, many different people can contribute to that, and it doesn't have that same limitations as the stable account. It doesn't have doesn't have Medicaid payback. It doesn't have contribution limits. If you've got a whole community there that's pitching in, having the third party wholly discretionary trust may be a better option even than a stable account. So pros and cons of the special needs trust. Well, the benefit is that it is probably the most flexible of any of these arrangements. It can hold any type of property. Anything that an individual could own, the special needs trust can own. So a house, a vehicle, life insurance policies, you name it, the special needs trust can own it, and that whatever is in there is not considered a resource for the beneficiary. You can assign income to the special needs trust, some income streams to the special needs trust. And if you have a substantial amount of assets, you know, so if somebody has received a significant settlement, it allows for those assets to be managed by somebody who knows them personally. You know, you get to select who your trustee is, so you have that close relationship there. The downside, of course, for special needs trust is that they are the most complex and expensive option. You know, you have to get attorneys involved, the courts involved. There's hoops to jump through. There's lots of details to it. If you need professional trustees, you know, a professional trustee such as a bank or trust company, that's going to be the most expensive option for management. So they're really only justified when you've got either a substantial amount of assets or there's a particular need for something that only a special needs trust can do. And they have limited applicability if there's older individuals, because again, once you turn 65, the special needs trust, the private special needs trust is no longer available to somebody who's over 65. They will, if they have one and they turn 65, that's great, no problem, but they can't add to it, and you can't create one on behalf of somebody who's over 65.
I would also add to that the food and shelter distributions, payment from a special needs trust for food or shelter is going to cause a reduction of the SSI. And so in those situations, and I think George might have already mentioned it, having a stable account is a better alternative, because under the rules, the stable account can be used for food and shelter and there's no reduction. So sometimes we might have both. So we might have a special needs trust because maybe there's a sizable amount of funds, or even when there isn't, maybe we're receiving child support for that child and we want to be able to not have it treated as income. Or we just like the idea of a special needs trust because we want to have somebody that we trust managing those funds for that individual. But we also want to be able to supplement their food and shelter. So we might then have the special needs trust holding the chunk of the money, and then have a stable account that the trustee can transfer funds to on a periodic basis so that it can be used for food and shelter.
So do you want to talk about the pros and cons of pool trust?
Sure. So pool trust, remember, is another type of a special needs trust. We're just calling it functions the same. We just call it a pool trust because it's a bunch of trusts that are being managed by a nonprofit. So the pros for a pool trust is that there's no limit on how much can be deposited in a pool trust. There's no age limit in Ohio, so it can be done by anyone. Remember the exception for someone who's over 65 in SSI, they are going to get dinged for potentially a period of time. But otherwise, it can be established for anyone of any age. And it's less expensive than if we had, say, a bank or some trust company managing the administration. There is a fee associated with it, but it's much more reasonable than a bank or a trust company. And I'll add another pro is that when we don't have anyone else that can be managing a special needs trust as a standalone trustee, then it's a good option to have a pool trust. The drawbacks is that it's only going to be able to hold cash, and then the other is that if the beneficiary wants something, well, it's not like a standalone trust where you can call the trustee and say, hey, I need new furniture, or I want to take a trip, and the trustee pulls out the checkbook and writes a check. With a pool trust, you're dealing with that entity. And so sometimes it can take a couple weeks before you get the distribution. And that's because when the distribution request is submitted, which is a request for the trust to pay something, then sometimes they has to go through their committee because they have to look at it, and they're not looking at it from the perspective of like, oh my God, they want how much? It's not that. It's more about, is this a type of request that might jeopardize the person's eligibility for government benefits? And sometimes it's a challenging question, so they may have to run it through their committee, so it might take a couple weeks. The other drawback is, unlike a standalone trust where usually the trustee and beneficiary know each other very well, in a pool trust situation, there's no personal relationship. The individual beneficiary does not know the people that are running the pool trust and managing their funds. So that can sometimes be a drawback.
And I just would want to add, maybe to make it more clear as to the way that these pooled trusts work, is that the trustee of the trust is that nonprofit organization. They're the ones that hold the purse strings, but the individual with disabilities will have somebody who is responsible for communicating with the pooled trust company. They may be called the designated advocate or the personal representative or something like that. And that is the person who makes the actual request for distribution and communicates with the trust company and handles all of that. So, there is somebody then. The individual can be their own designated advocate, but typically there is somebody else who serves in that function. So that's the person who deals with the pooled trust folks more often than the disabled individual themselves.
Right. The other thing I would add is that the pool trust, at least the one that we work with here locally, they have more of a passive role. So it's not like they're looking out for that individual beneficiary and checking in with them to see how you do and do you need anything, which is different than a standalone special needs trust, where you, again, if you have a relationship that trustee knows the beneficiary, or maybe they've hired somebody to be a care manager or care advocate that can regularly visit that individual and report back to the trustee. With a pool trust, it's a much more passive relationship. So they rely on that designated advocate that George was talking about, that person who is authorized to make requests on behalf of that beneficiary, to come to the trust and say, hey, we need something. If they don't, then the trustee is not going to do anything proactively. So that's something to keep in mind, that you still need to have some in that setup. You still want to identify a person who's going to have a relationship with that individual, so that they can do the communicating with the trust as needed. All right, so I think we've reached our final slide, so we can open it up for any questions or comments folks have or anything. Yes, I see something. Oh, well, you're welcome.
Oh,
all right.
So let's see. Here I will.
While George is looking, let me just say that this doesn't have to be, we did the comparison with the special needs trust and the stable account. This doesn't have to be an either or situation, that one is better than the other. In some situations, the family will have both things because they're different tools to achieve different things. And in some situations, one is better than the other. So it's really more about just giving you the information. So hopefully you have a better understanding from our discussion today of how they work and what the pros and cons are of either one.
Yeah. So, yeah, I think if you want to use the hand raise feature, you can do that. I'm gonna stop my screen share here. I think that's what is preventing me from seeing those. Okay. Yeah, you can either use the hand raise feature or type something into the chat box, and we're happy to answer that.
I saw a question earlier on that I don't see it now, but it was about, the person was asking whether SSI is same as SSDI.
Mhm.
And so the answer to that is no, they're both administered by the Social Security Administration, but they're different programs. So SSI, which is what we've been talking about this morning, supplemental security income, is available to someone who meets Social Security's definition of being disabled, and they have countable resources or assets below $2,000. And so you have to pay attention to the money, because if they go over 2,000 or they receive income, that's going to affect their SSI. SSDI stands for Social Security Disability Insurance. It doesn't matter with SSDI, the eligibility criteria are: number one, you have to be considered disabled, meeting their definition of disability, and you have to have worked and paid into the Social Security system, and then you become disabled. Then it's kind of like your insurance plan. The Social Security will pay a SSDI benefit to that disabled individual. They don't look at money. You can be a millionaire, you can win the lottery, but if you're disabled and you paid into the system, you will be entitled to the SSDI. Now, some children who never worked, who became or met the criteria prior and were considered to be disabled prior to age 22, they may also receive a benefit or become eligible for a similar to SSDI benefit off of their parents' work history, if that parent worked and paid into the system, and they would become eligible either when that parent retired or became disabled themselves, or they passed away. Then that's when that child might be able to get that SSDI benefit. It's called something else. It's disabled adult child benefit, but it would be the same thing, that they wouldn't have to worry about being over $2,000 because it's not needs tested.
I heard a good way that somebody described SSDI to me is that it's you taking your Social Security early because you have become disabled and can no longer work. That's the difference. SSI is more of a welfare type program where somebody can't work, they have no way of earning income, and so this is a way of making sure that their basic needs are met. Whereas SSDI is you've earned your retirement early because you are physically no longer able to work.
Okay.
So,
all right.
Any other questions?
Okay. And once SSI stops and the income and asset limitations no longer applies, is there still a need to or advantage to maintain a stable account? So that the answer to that is it depends. Does that person need Medicaid, or are they on a Medicaid waiver? If they are, then you're still going to want to you still are going to be subject to the $2,000 limit. So in that scenario, you might consider a trust or a stable account because it's the same financial criteria as SSI. But if that person is not on Medicaid, or say they start receiving SSDI, one of the if they are eligible for SSDI, either off of their own work history or a parent's work history, then 24 months after they start the SSDI, they will automatically get Medicare. And maybe at that point, they may say, well, the Medicare is sufficient, which is another insurance program. Usually it's we think of Medicare as being the insurance plan for our seniors, age 65 and over, but it's also the insurance plan that covers anybody on SSDI. So you might say, well, okay, then I have Medicare, so maybe I want the freedom of controlling all my funds and not having them subject to stable accounts or special needs trust. So I'll give up the Medicaid. Typically, This is not a lot of people don't want that option because Medicare, unlike Medicaid, covers only 80% of your medical costs, and then 20% is out of pocket. And Medicaid in that situation will pick that up. Also, Medicaid is way broader than Medicare. So Medicaid will pay for the cost of long-term care. If you have a child that's got a Medicaid waiver through the county DD board, then you probably already know that the Medicaid waiver covers way more than just health coverage. It'll pay for supports and services that person needs that'll help them be as independent as possible. Things like transportation or job coaching, or somebody coming in to help them at home, those kinds of things. So typically Medicaid is the one that's really, really valuable that people are trying to protect.
Right. Yeah, as somebody points out here, Medicaid is still going to cover things like prescription costs, out of pockets, co-pays. Medicaid will even pay the Medicare Part B premiums. So the person is going to get more of their SSDI income than they would if they weren't on Medicaid. So it's generally, unless as Ellen has said, you have a real desire to have much more direct access to your funds, even then with a stable account, it's generally a good idea to hang on to your Medicaid benefits if you can.
All right, I think we're winding down here, George.
I think so. I think for once we actually got through all our material and wrapped up in a reasonable time.
Good. Well, thank you for joining us, everyone, and taking time out on your Saturday morning. We hope that this was information that was useful.
Yeah. And if you have more questions, or you have questions particular to your specific situation, give us a call. The information was on that last slide. I can put that up here again. And we're happy to, I'm happy to talk with somebody for 10-15 minutes about something, or we can do a full-on consult if you really have an issue to address, or some work that needs done. We are here for you.
All right. Thanks, everyone.
All right.
Bye.